Sergeant Steve Pope, who'll be talking about key things from Victoria Police's perspective that he thinks is really valuable for us to know, in our disability-related roles in the system. Good luck.
Thanks, Glenn. Look, firstly, I'd like to thank Glenn. He's been running these for a number of years now. I think it's a great opportunity to bring together a number of sort of agencies. I think it's really important, as Emma was talking there, to get a sense of what roles and responsibilities and maybe what barriers police might have, what legal services, ITP programs, etc. So whilst I give you a bit of an overview, I would strongly encourage you, if you have any questions, please, this is a very good opportunity. I am more than happy to speak at length about anything. So if you have that what-if question or that hypothetical, I'm more than happy to try to break down some of those barriers. It's certainly better than me just talking away about something that may or may not be relevant to you. As everyone will be well aware, family violence is certainly a priority within Victoria Police. And if you speak to any frontline sort of first responder police member, it takes up a huge part of their day-to-day sort of activities. We do have a code of practice, so it's very much what I think. I've been in Victoria Police 26 years. I think of how we responded to policing or family violence incidents in those first days. It was very much keep it in the house, and we weren't that sort of concerned. If you could sort of self-manage, we were quite happy to leave it with you. Now we're very prescriptive about what we do. And that's probably really important for you guys to understand that, as Emma was speaking about, I know I'm actually at the Police Academy at the moment, that I think that nearly 30% of our members have 5 years or less experience. So you will be potentially dealing with someone that is very new at their role. So we're an organisation that's very heavily, I suppose, policed in relation to policy and rules. So most members will follow those policy and rules. Look, to give you an example of that, if you call police and we have concerns around the threat or actual violence being taken place, police are mandated they must do something. So this might really conflict with you with some of your clients where you go, but I don't actually want you to remove that person that suffers an ABI from the family unit, because that might actually cause more problems than actually look for solutions. But just understand that when police attend, if that family member has actually disclosed threats or violence, police must act. So that will be removing that person from the family house, most likely taking them back to the police station where they will be interviewed. The allegations will be put to them. They'll be fingerprinted and photographed. So they will be treated like any other, I suppose, suspect through that sort of criminal justice process. At the end of that process, a determination will be made about what civil steps can be taken. So that may well mean by giving an intervention order, a family violence safety notice, which precludes that individual from doing certain things. And the biggest thing for those where you need the family support might be not to go to the family home, not to have contact with the family member. So we can quite often see that you call the police wanting help, police come there, they remove that family member with that acquired brain injury, and you go, great, you really haven't helped the situation at all. Have people had experience with that? Do people understand that that's the process? So we're trying to take it away from individual police member trying to make that decision. It's what we call a pro-arrest policy. So if a disclosure is made, they must act. So if that family member says, I've been assaulted or I've been threatened, we must then put that allegation to the other party. So that means a formal interview. And then depending on if that person makes a disclosure that, yes, I did hit her and I hit her really hard, we then have to charge. Okay. Now what complicates the situation is that family member, having made that disclosure, may or may not want to make a formal statement and have the matter progressed at a later stage. So where to from there? We're trying to, for someone that has a 12 and a 10-year-old, I understand the idea of the concept of setting boundaries and having consequences. So I think that becomes a real challenge for us. So in my previous role as a family violence liaison officer, if that family member then wants to remove that statement that they've made that implicates that family member, I want to know what's in place to either reduce or remove the risk of this happening again. So in my role, I was very reluctant just to go, that's okay, we'll remove that statement and we will just shelf that investigation, not take it any further. So you would need to sell it to me as to what's in place. So I think that services like Glenn and others would certainly go a long way for me being satisfied that I could, on our LEAP system, you think of worst case scenario, if this turns out months down the track where it's a coronial inquiry, my members are going to be scrutinised at what steps they took. So if they can show they've taken some positive steps, and again it's removed from them, it's where the sergeant would come into place, I think you'll get a lot better traction with members. But just understand that my members are very outcome driven, and if they're going back to the same place time and time again, they want to help, and I suppose that's where the policy very much mandates what they can or can't do. Does anyone have any questions around that part of the process?
When it is someone with an ABI, is that taken into account? Say the family member is their carer. Is the process different, or is it's unyielding?
It's pretty much unyielding, yes. Yeah. And look, I will say is that when you talk about family violence safety notices, if that person has a cognitive impairment, you can't actually use that family violence safety notice. Then family violence safety notice is the one that police members can initiate themselves on the spot. So that's maybe one thing that members may not be acutely aware of. But you're right, when you start talking about these complex problems, great, we've followed our policy, our code of practice, but we've just created a whole range of other problems sort of for you. So, but it's a really good point. So I think that in situations like that, if we're trying to look for solutions, I think that's where the likes of Glenn and other people, if you've got case managers or whatever, that I would want to be speaking to them about what can we put in place. Just having the undertaking of someone saying, look, it won't happen again, unfortunately, in this risk-averse world, it probably won't fly. And I think it's important for you to understand that, so it's not just the police member not being sort of particularly sort of caring of that. I can tell you every time that there's a family violence, domestic homicide, the first thing anyone will do is race to that LEAP computer to go, have we been there before? And was the action we have taken each time appropriate in the circumstances? And it's a very nervous person that goes, ooh, reading the narrative there, it's there forever and a day. Yeah, it's not a nice place to be in. Yeah.
This might be something you want to save till later, but I'll ask it now because you asked. Because you said that you will, if a family violence incident is reported to you, you must take a step, and it seemed you implied that there's no question that there'll be an interview taken and possibly charges. That if a carer is the subject of family violence, and it can vary from minor to very extreme issues, that they would, in the past perhaps they would have had a police officer come around and straighten things out, so to speak, and bring in that kind of instant response you were talking about correcting behaviour. But now, in a sense, it's pushed underground because they know that if you come, everything will go from 0 to 1,000% immediately, and in a sense, if they had the choice to have a police officer come round and make a firm statement and warn the person and so on, they would have taken that. But now they may actually prefer to do nothing.
So it's what we call that law of unintended consequences. Absolutely understand that the implications of that may mean that family members do not make that disclosure to police, knowing that there isn't much wriggle room there at all. I certainly, in my role, understand that. I'm not too sure that, it's either it's on or it's off. You're sort of either pregnant or you're not. So, again, I'm not too sure that there's there's sort of any middle ground sort of for that, because that's probably where police find the trap. If we create it grey, they then sort of, because there's so much work involved in family violence, about interviewing people, the paperwork that's required, compilation of matters to go to sort of court, if they're juggling a number of balls, there is that risk that they go, well, okay, we'll downgrade that one to that we don't have to do anything. And I suppose the day's gone by of the old sergeant coming out and sort of, as effective as it was, giving that person a kick up the backside and that sort of harsh talking to, unfortunately or fortunately, are well behind us. So I understand the comment you make, but the code of practice is fairly clear about what we can and can't do. I mean, that might mean that when we go to court for that full intervention order, that you do get those support people around, and that's where, we have mandated to say no, we're taking some intervention, but then it's up to the court then to then make that decision. So we might go, look, we have taken that intervention, but however, if there's some other things put in place, we're happy to support that order being sort of conditional, that they can still stay at home or have contact. Has anyone had issues around police where we don't actually charge someone, where you've reported something and matters haven't been sort of progressed through the criminal justice process? Okay. What were the circumstances, or how was it sort of relayed to you as to why that?
I think for me it wasn't personal, it was the neighbours, and it's a constant ongoing issue. The neighbour's always drunk, the girlfriend's always drunk, they're always bashing each other or smashing things or threatening me because I want to sleep with the guy. Yeah, yuck. But that's beside the point. But it comes to the point where, it's an ongoing cycle. It's a constant thing since they've moved into our area, and I've taken out intervention orders. I've taken out an order where she can't come into the court because she's the issue, more to the point. But she just walks in anyway. Instead of driving a car in, she walks in.
So
and the police, we ring, the police come. The police officer got on her, wanted to throttle her, I think, but never goes anywhere, never seems to go anywhere.
So that's a really, really common problem. So when we sort of talk about those orders that can be placed on the court where it's not in a family setting, but sort of it's a neighbourly sort of setting, is that police will come there, they'll get an account from you, they'll then get an account from the other party, and they'll be conflicting. So what you need to understand that in a policing context is that the police member, so that constable, senior constable, would need to, depending on the level of the seriousness, would have to compile a brief of evidence. So they may, if it was a serious matter, get a statement from you, might interview the other party, they then put all that paperwork together to the sergeant, and then makes an objective an assessment as whether he thinks, and these are the key words, a reasonable prospect of a conviction. So if he doesn't believe that there's a reasonable prospect of a conviction, the matter won't be authorised to progress to court. So the real trouble you have in those scenarios every day of the week is conflicting stories. So then we look for corroboration. And I was previously a detective, used to train at detective training school. So we would look for corroboration. Were there any other witnesses? Was the physical evidence, etc.? So quite often in your scenario, you're relaying to me, it's the old he said, she said. So for those lower matters where it doesn't get to court and police don't take action, so in that case it sounds like police are taking action, it's probably those ones that fall below that threshold. The reason for that is that police need to apply that test. Not that there's any of your concerns, but if we put matters up before the court and they're deemed to have been sort of fairly shallow in evidence, defence are able to make an application in relation to the costs. So, police being fairly risk adverse go, well, hang on a moment, if that doesn't meet that threshold, we're not going to progress the matter. So just need to sort of understand that that test is going to be applied on each and every occasion. I spoke about the pro-arrest policy. All right. Criminal Justice Diversion Program. I worked on Victoria Police's mental health project back in 2006-2007. And probably this was something that I was really wanting to sort of, push its use and its application much greater than what it currently has been. Just so you understand, the majority of criminal justice diversion programs will result in a fine or a letter of apology. Now, if the causal factor to the offending is someone has an acquired brain injury, clearly writing a letter of apology or making a donation isn't going to address the causal factor. During that process, the diversion coordinator can actually make recommendations where it might be engaging one of the services. So I was all for trying to actually address what the causal factor of the offending was. The other interesting part about diversion programs is the legislation talks about needing to take responsibility for your offending. What does that mean for police members? Having spoken to the Chief Magistrate, in most cases that means admissions. The irony of that is that someone's legal practitioner, solicitor, will most likely give the advices to make a no-comment interview. So we have this, again, not saying one is better than the other, but it's interesting if we're trying to sort of address the needs of the individual, and we think by giving them a diversion will avert them from getting a criminal conviction and, you know, going through the court system proper, and maybe addressing some of those causal factors, you need the police to recommend it, okay? So the police must do it. If the police don't recommend it, you don't get to go to the next stage. And that next stage is the diversion coordinator at the court then making a recommendation about its suitability, and then obviously it's up to the magistrate as to what sort of conditions are imposed. So what's interesting for me is that my members may have brought a suspect and accused in, have interviewed them, they've made a no comment interview, and then our solicitor on court day goes, oh look, I think they'd be suitable for a diversion, and our policeman will go, well, they would have, but they didn't actually take responsibility, so you have this sort of awkward sort of position where police members go, well, no, that hasn't. Now, having said that, if that person, and this is the grey area, if that person was to take responsibility at court and go, look, yes, I did do what it is you're alleging me to do, but police being sort of that sort of almost sort of driven by those rules, is you didn't actually do that when we had sort of the interview. So I'm not saying that every offender with an ABI should come in and make full and frank admissions and all the rest, but just so you understand, that can create a bit of an issue in relation to whether police can recommend someone for that diversion program. I mean, I would like to see that our diversion coordinators had access to a whole range of other services, so it was actually that therapeutic justice as opposed to just a numbers game of just moving people through with a, as I say, a donation or a letter of apology. Any questions in relation to the diversion program?
I'm a community lawyer,
Yep.
a community legal service, and what I see quite often with clients that might have either intellectual disability or a significant mental health issue is, you know, a real difficulty having insight into their conduct, and accepting responsibility then becomes quite a difficult proposition. Partially, you know, I find the offending might be attributable to the condition, and the client's not willing to kind of accept that. Any suggestions about navigating those sorts of issues of...
Well, maybe the other part to sort of throw into that too, so whether you're aware or not, but under the mental impairment provisions, if in the magistrate's court, if the accused is deemed to be not have that mental capacity, is that the magistrate cannot impose anything, and the charges will be dropped. So that's the first part to it. If it's in the higher jurisdiction, there's capacity for in the county Supreme Court to put things in place. But yeah, at that sort of lower level, it's a really, really tough one. I mean, the first part might be about whether, and this is the other, I suppose, interesting part, when we talk about that mens rea, which is that guilty mind. So if you're talking about some of your clientele where you go, do you know what, do they have the capacity to form that guilty mind? From a prosecution perspective, that's an argument for defence to raise. You will have some police that will sort of make that decision themselves and go, oh, no, I don't think they're at that sort of threshold, so I'm not going to progress the matter to court. But if we do progress it to court, I suppose that textbook response would be that it's for defence to sort of raise. So, yeah, I share your pain if and if you're working towards the best outcome for that individual, trying to sort of get them to that sort of point, so where that police member goes no until they have that sort of yes.
And sometimes it's also getting the prosecutor to the point of accepting that the condition, you know, is the intrinsic factor behind it.
And that's why I see diversion has been such a maybe an underutilised, I suppose, option. Because what happens is that so police members will quite often probably see diversion as being a soft option, which I actually think it's gives some ownership to the police member to then put some, as I say, some options up for the court to consider. And if the individual doesn't adhere to those conditions, doesn't fulfil them. So if it's a case they've got to engage with something like Glenn's service, on a 12-week program or whatever it might be, if they don't, the matter is then adjourned and they go back through the criminal justice process just like any other accused. So I think in the selling of diversion, I think there's great upside, but at the moment it just seems to be very much about people in, people out. So the other part I would say is that, again, if you're having, if it's some of your clients, I would strongly sort of recommend that if you have some ideas around sort of conditions in relation to a diversion notice, step up and just suggest to the police member, that the reason for their offending is X. And I know a really good, I've used Glen Service before, so I think that sort of the old, you don't know what you don't know. So you people working in the sector, you may be able to sort of just make that sort of suggestion to that sort of police member, and they may be, very much inclined to sort of put that forward.
My name's Galit. I work at Fitzroy Legal Service, and I had a question about...
That wouldn't be very busy.
Sorry?
That wouldn't be very busy.
Not at all. Walk in the park. I had a question, because diversion is something that needs to come from a referral to police. My experience is that often where the charges are assault police or resist police, it's often police are very disinclined to refer. And I often find with people with mental health issues and ABIs, it's often very likely that they might find themselves facing those charges because of their difficulty regulating emotions. And I thought I'd just ask whether you had any tips about how to advocate for such a client to be referred to a diversion program in circumstances where for other offenders maybe it wouldn't be appropriate for assault charges, but because they've got these mental health issues, maybe there's a different perspective. And that could contribute to the overall cause that we're looking at about how to reduce people with ABIs having contact in the justice system.
My understanding is that it has changed. It always used to be the informant that had to be the one that gave that sort of thumbs up that, yes, I was happy to recommend the person for diversion. My understanding was now that the prosecutors can actually make that recommendation. So maybe the first part to that barrier you spoke about, if I'm a member that's been assaulted as a result of having to arrest one of your clients, I'm emotionally invested. So I can understand the part that police member that is maybe victim is unlikely to then sort of go, yep, I'm happy to recommend the person for diversion. So maybe by at least removing that step one part away, that maybe now I'm not saying you're going to have a great sort of uptake on that, but maybe there's far more likelihood these days at least that diversion could at least be made by the prosecutor as opposed to the police member involved. Interesting, it talks about that normally it's for just first-time offenders. There's nothing in the legislation that says you can't be given a diversion on a second occasion, which again I think it sort of just goes down to we've never normally done it for a second occasion, but there's no reason why it couldn't be used for a second occasion. When I was on the mental health project, we did a fairly wide sort of external, internal sort of consultation process, and one of those advocate groups spoke about their particular child that suffered autism and had a real fascination with, I suppose, CT type incidents and bombings, which is interesting because that was back in 2006, 2007. So when you think of what's taking place in the world at the moment, it's even more relevant. And she said that due to the sheer fascination of bombings, that whenever he was out and about on his own, he would act strangely, he would be talking about it. So if you happen to be at Parliament Station and you saw this particular individual, you'd be very much on edge. And she said that there'd be every chance that the police would be called. So she actually threw up the notion about, there's some really good strategies that we could actually give you for, when police come in contact with my son. Is there any way that we could volunteer that? And we've gone, volunteer it. So to go back a step, a person warning flag has a number of criteria for it. So it might be someone that carries drugs, it might be someone that is aggressive. There's a whole number of other sort of factors. And normally these are after an incident. So if we have that incident where your client has had to be arrested because they're affected by alcohol, and as a result they were, we had to go hands-on, there would be a notation there, most likely, about the assault police and that sort of potential for a propensity sort of for violence. So that would sit on our system, not to help us in that incident, but if police were to come in contact with that other person. Where that became really helpful, I suppose, is with our D24 or our communication centre. If you were going to a family violence matter, they would do a check on who lives at that address, and part of that contract is they would need to have a look to see if that person had any person warning flags. So if we were going to a domestic and the husband had been involved in some serious assault sort of matters, we would actually be armed with that sort of before we, or carries weapons, we'd be armed with that information prior to sort of attending. So normally it was to help members that came into contact with this person at a subsequent encounter. So this particular advocate group spoke about this ability to sort of volunteer information. So it's not a case that we wanted to sort of capture every person with a mental disorder of every description, so he had some sort of profile and or big database. The criteria was around those people that are likely to have contact with police. And as that individual or as that sort of carer, or when I say carer, it actually needed to be someone who had that legal sort of guardianship, was able to volunteer that information. And some of that information would be around what sort of communication strategies, who that contact person was, how they would present, how to maybe de-escalate things. So it was very much some of those key things to help police deal with a potentially escalating incident. So what would happen there is that last time we did this down at Geelong, there was some of the custodial nurses at the prison, at Barwon Prison, talking about they'd been working with some of their clients and were going to be released shortly. And they said we'd have a number that they would be more than happy to sort of disclose what some of those strategies are. So if they had contact with police again, that they wouldn't find it escalating to the point where it maybe sort of became sort of hands-on. Again, there were just some of the triggers or some of the sorts of information that we would gather on that person warning flag. So this is our 20+ year LEAP system. Probably the most successful IT program that Victoria Police has been involved in, and still ticking away. So that's how the first page would come up and would show that they had a warnings risk. So you would then hit on it, and that's what some of that information might look like. Has everyone read that?
Do police on general policing have access to this in their cars?
Yes, they do.
Okay.
Okay, so there's probably 2 ways or 3 ways that information can get on there. First, that can be generated by a police member. So I can make observations about a particular person. So I might have had to go arrest an offender for drunk, and I found, a big Crocodile Dundee knife on them. So I go, oh, hang on a moment, this person carries weapons, so I'm going to make a notation of that. So that would just forewarn someone else that came across this person, they might have the propensity to sort of carry weapons. So that's the first occasion. Second occasion, under the voluntary system, could be the individual themselves providing that information. Now that might be in conjunction with their carer, or the other part would be that sort of legal guardian or that sort of parent. So you couldn't just have, as much as it would be nice to have that carer come through and go, look, I want to give you this information, which is really important. We would, in that instance, we would need the individual to sort of come along and go, yep, I'm happy for that information to be given. But some of these management, like this is obviously just on our system, but we'll have management plans of some of our frequent flyers at different sort of police stations where there is, some information that sort of really helps us as to what to do, who to call.
If police were to get information from a mental health service, is that where the information ends up on LEAP? I'm asking because I work for Barwon Health and I'm involved in the PACER program.
Yes. Yep. That's one of the places the information may sit, yes. It all sit on LEAP. Otherwise, some of that information just sits on running sheets, that hand copy running sheets that just get filed. So clearly, if it's important information, it needs to sit on the system that's accessible sort of 24/7, sort of anywhere in the state.
Brendan over here. Just wondering, how do you qualify to get onto the LEAP system for a start? And if you're an external organiser, if you're an external person or you're not the individuals, who do you call?
Okay,
so who would a caseworker call to get the alert?
So I'm on the LEAP system, and there'll be many other people here that are on the LEAP system. So if you've been a victim of crime, you'll be on the LEAP system.
No.
If you're an offender, yes, clearly you'll be on the LEAP system as well. You could be a witness to an incident, you'll be on the LEAP system. So when we implemented the project, we had a mental health liaison officer at each sort of station that could actually be that sort of contact point. So I must say, driving in today, I thought, I wonder whether that role still sort of exists, and it doesn't surprise me that it doesn't. So that's about building those relationships with your locals and sort of going, because we know that very much it's around sort of, it's person dependent. So Glenn will ask me for something and I'll oblige, and sort of vice versa. So I think having those relationships is very important, and a skill that's well lost, I must say, as well.
Thank you. I'm just wondering about if an individual has asked a warning to be put on, if they subsequently want it to be taken off, will you do that?
Good question. Yes, if they haven't come into contact with police, so if they say that, look, I might present like this, and this is how best to sort of deal with me, and then they make a decision they want to remove it, and we've had no contact, we would remove it. If we've had contact with you, my understanding is that we'll go, no, well, that information is going to be, as a result of us having to deal with you, we'll keep that information. But it's supposed to be really practical information. To be perfectly frank, I don't care whether the person suffers an ABI or has whatever sort of mental disorder. It's just about how does it help me to, if it's about, make sure that your communication is really simple, one task or question at a time, or just contact this person, great. That could save them 30 minutes trying to sort of manage this particular incident.
I've had quite a different experience to Brendan. I've done this a lot without knowing about the LEAP system. I've contacted local police stations and talked to the sergeant mainly, and they've always been very helpful. I've always had the consent of my client or the guardian, and they haven't used this language, the LEAP system. They've always used the language of a dossier. We'll put it on the person's dossier, and they've taken the information generally, some strategies and that kind of thing, and I'm pleased to say it's actually improved future interactions between the police and my clients, so it's something I'll continue to do.
I know it's a dangerous area we get into when we start gathering information about particular sort of individuals, but certainly from my experience it very much is about trying to sort of turn an unplanned situation into a planned sort of response. So as I say, our operators at D24, or ESTA as it's called, will have access to that. Part of their contract is they must, if they're going to an address, they must actually check and read the... so it's interesting, dossier is a different area. They're not obliged to actually read all that information. And if you think of D24 as like mail in, mail out, so as they're taking all those calls, they want to get those jobs out as quick as they can, but they must actually read the person warning flag as part of the contract. That's it. Any questions on any policing sort of matters that...
On one of your slides before, you had a point about you identify the aggressor in family violence. How would you go about doing that?
It's no more complicated than, and again, if I put my detective training school hat on, so you'll get sort of an account from both individuals. You may speak to neighbours, you may speak to other sort of family members. It's always interesting when we start talking about children, about whether we do or don't talk to children. For someone that has, say, a 10 and 12-year-old, I think their, the ability to, I know it can be sort of maybe divisive between mum and dad, but that ability to get that sort of, a much truer account, I certainly take that opportunity too. Physical evidence, then is a case of looking at sort of past behaviour, so doing LEAP checks on both individuals to get a sense of what's taken place. Every time we go to a family violence matter, there is a record and a narrative of what took place. So you can start to read and start to see sort of what the patterns of behaviour have been over, either a short or an extended period of time.
With the whole, if I'm aware, if someone comes to me, I work for corrections, and if someone I know has a current IVO and he might say to me, yeah, I'm still at the house, or we had a fight last night or whatever, he might disclose that he's breached that IVO. My understanding is that if I call Victoria Police, they can't do anything about it because it has to be reported by the AFM?
Incorrect.
Okay.
So I can't tell you how many times that we will have, and we'll get a call from that neighbour. I'm hearing screaming, shouting. So I'll come to your door, if it's you and your partner, and I'll knock on the door and you won't answer. I can tell you I'm not going until you answer the door. That's a red flag for me. So there have been examples of that where police have gone, oh, well, I knocked on the door, no one answered, so I'll assume that everything's okay. So from that perspective, in this current climate, I would not be leaving until I actually saw. And if your husband came or a boyfriend came to the door and he said, no, everything's so fine, Ali's gone to bed, and I've gone, no worries, I want to see her. I'm not going until we see her. So you can either tell her to come or we're sort of coming in.
I just wondered, in those sorts of situations like you just described about where it's maybe a mutually violent domestic household, do you scrutinise what information one half of that partnership might give on the other for the LEAP system with regard to their person warning flag?
It is really tricky, and I must say that, which I might be going off on a little bit of a tangent, but sometimes I'll see when we put conditions on family violence safety notices or intervention orders, if the causal problem is the drinking, to put a condition on the order that says to abstain from alcohol, I go, you're setting this person up for failure. Like, we know that just by putting that condition on the order isn't going to change behaviour. So for me, it would be more a case for trying to go, well, I need you to maybe address like AA or men's behavioural change program or something like that.
So I was just wondering, basically, could people in a troublesome partnership like that almost use it like a backdoor way to put information in the system about their partner in their favour and against their partner, basically?
Yeah, potentially, but I suppose police will make that sort of assessment as to the validity of that sort of information as best they can.
I had a question about when police serve intervention orders. So let's say someone with an ABI doesn't come to court, an intervention order is made in court and police are going to serve it to them. My concern is to making sure that people actually understand the conditions of the intervention order, if it's in writing and it's given to them. And I was just wondering if there's any kind of guidance as to how the police do that and whether they involve independent third persons in that kind of process.
Good question. Emma might be able to answer that one as to whether I'm not. My thinking would be it would probably be unlikely that police would be engaging an ITP to, as I say, explain the conditions of.
It would be overall probably quite helpful for some simpler language attached to the family violence intervention orders, because this is a comment we have all the time. So at a station, if that happens, the ITP explains it or attempts to break it down, but certainly the orders can do with all of policing language a bit of breaking down for people, and I don't think that would be happening. People do try, I know they do try, but it's a bit difficult. Sometimes it would be helpful for VicPol to produce something that has, a bit of a step-by-step, this is what this means thing.
Which is interesting you say that, because if you talk about our caution that we give someone that we arrest, you're not obliged to say or do anything you say or do may be recorded and given evidence. You may communicate with or attempt to communicate with a legal practitioner. I mean, it's not the sort of language you may attempt to communicate with or attempt to communicate with a friend or relative to inform that person of your whereabouts. It's not really simple sort of language, so the police are taught to use, yes, the language like that, and then if the person doesn't explain it, you can use simpler English, but I think Emma's point is a really good one.
We've had lots of questions, which is good, and Steve will be around in afternoon tea, which is coming up after Viv. So catch up with him then.